being recorded. This webinar is being recorded, as you just heard, and that recording will be available on the Center for Children's Advocacy's website and sent to all registrants today. And after the conclusion of the webinar, all registered folks will receive a follow-up email with any resources and links and the PowerPoint presentation. So be on the lookout for that. As I said earlier, I'm Stacy Violante-Cote, Director of Operations at the Center. The Center for Children's Advocacy is New England's largest children's legal rights organization. We are a nonprofit law firm providing legal representation and advocacy for children and youth who are most at risk. CCA staff has offices in Hartford and Bridgeport and are located in community sites throughout Connecticut, including hospitals and schools. Our work also brings us into courts. We work with the child welfare system. We're in juvenile justice facilities, and we cannot do this work without the generous support of our donors. We're particularly thankful to those who make today's presentation available, which is Connecticut Division of Public Defender Services. We also have with us today Esperanza Attorneys at Law. Esperanza is a low bono law practice that provides direct representation to immigrants navigating the U.S. immigration system. Esperanza predominantly represents individuals and families seeking relief from removal on humanitarian grounds, including unaccompanied minors, asylum seekers, and survivors of violent crime. Esperanza Law represents people seeking immigration benefits before the United States Citizenship and Immigration Services, or USCIS as it's called, as well as before the immigration courts and appellate courts. So in thinking about today's webinar, our thought was that we get questions from attorneys, service providers, clinicians, educators working with children and youth. They have questions about legal options for immigrant children and youth, everything from how the immigration system works to eligibility for benefits in Connecticut. The demand for legal representation and information and advocacy on behalf of immigrant children and youth is much higher than the supply. This is why the Center for Children's Advocacy has a pro bono project where we pair pro bono attorneys admitted to practice in Connecticut with immigrant children and youth who are eligible for one particular form of relief called special immigrant juvenile status. You're going to hear more about what that is in today's webinar, if that's not familiar to you. So your speakers today will provide an overview of rights and immigration relief for children and youth. I did want to make clear we're not in a position to provide advice on any particular case during this webinar, but we hope that this overview is very helpful for folks to provide context and information. So first, you'll hear from attorney Christina Williams, who will provide an overview of the immigration system, including the various agencies involved, the flow of children and youth through the system, as well as various forms of relief. You'll hear from attorney Sabrina Tavi, who will then speak about one specific form of relief, special immigrant juvenile status for abused and neglected children and youth. You'll also hear from attorney Tess Reagan, who will speak generally about the benefits that immigrants are entitled to here in Connecticut. And attorney Angelique Torres will close us out with some information about access to health insurance and the rights of English language learners. So if we could have the slides up. Here we go. And go ahead and advance us to the next slide. These are the speakers that I just mentioned, and I will now pass it over.
Okay, now.
Oh. Hello? Yes.
Making sure everyone can hear me. Hi. So my name is Attorney Tina Colon-Williams with Esperanza Attorneys at Law. And I'll be kicking us off by sort of walking us through, starting with an overview of what this immigration system is and how it works. A lot of times we talk about relief for kids and navigating the immigration system, but it can be really helpful to name who's who and what we're actually talking about when we talk about the immigration system that kids navigate when they first come to this country. So we can go ahead and advance to the next slide. So first, just an introduction as to which entities are really at play for youth who are entering the United States. The top three are outlined here. So we have the U.S. Department of Homeland Security, or DHS, U.S. Department of Justice, DOJ, and the U.S. Health and Human Services, HHS, DHS, DOJ, and HHS. And so walking through them one at a time, we'll start with DHS, because DHS really is the entity that in a lot of ways holds the keys and a lot of the discretionary authority as to who stays and who goes from the United States. First, we have USCIS, U.S. Citizenship and Immigration Services. This is underneath the umbrella of DHS, and this is the entity that handles applications for immigration benefits. Now, this can include a visa petition for a family member, green card applications, work visas, professional visas, non-immigrant visas like a student visa, or various forms, any form of immigration benefit. USCIS is often the first stop and the deciding entity for those benefits. When the language here says it handles applications for affirmative immigration benefits, affirmative and defensive is sort of the language for applications that are brought outside of the context of removal proceedings, and defensive are more in the context of removal proceedings, which we'll get into removal proceedings in a second. So USCIS is the decision-making body for most applications for immigration benefits in the United States. Then we have ICE, Immigration and Customs Enforcement. They are essentially the enforcement arm for the immigration system in the United States. This is the entity responsible for detaining and removing individuals. They come before immigration courts, and they are the ones who are responsible for initiating the removal process from somebody who doesn't have any legal right to remain in the United States. CBP is Customs and Border Patrol. This is the entity that is responsible for sort of guarding the border and the ports of entry. And this includes airports, land borders, and any area within 100 miles of a US border. CBP is responsible for sort of monitoring. A lot of times for the young people who come across the border with Mexico and the United States, CBP is their first point of contact. These Border Patrol officers who pause them, detain them, and transfer them through the next pieces of the system. Then we have OPLA, Office of the Principal Legal Advisor. This is essentially ICE's lawyers. DHS represent the legal representatives for DHS in the context of removal proceedings. So really, when you think of DHS, it's USCIS on the one hand, this office that decides applications for relief, ICE, the enforcement or like immigration police equivalent essentially, and CBP, the folks at the border, and then ICE's lawyers, which is the Office of the Principal Legal Advisor. So DHS, has a lot of discretionary authority. They're governed by particular rules and standards as to who's eligible for what, but in pretty much every form of relief, there is a fair amount of discretion that is given, discretionary authority that is given to the folks within DHS. Then you have the immigration courts. This falls under the Department of Justice. These immigration courts are not in the judicial branch the way traditional courts are. These are administrative courts under the executive. And they fall under the Department of Justice. And the name for the agency that runs the immigration courts is the Executive Office for Immigration Review, EOIR. And these immigration courts are in every single state at particular locations, and there are different numbers of immigration judges in each state, depending. And these are the entities that preside over the removal process. So whenever ICE initiates removal proceedings, those removal proceedings happen under EOIR's umbrella. And then you have the immigrant on the one hand, and then the OPLA, the Office of the Principal Legal Advisor attorneys on the other hand, sort of in an adversarial way, deciding whether or not an individual is eligible for relief or whether they should be removed from the United States. So the immigration courts is under EOIR. The next big player in this system is the Attorney General. The Attorney General leads the Department of Justice and ultimately is in charge of immigration-related decisions. They're in charge of all of it, of EOIR, and of the Board of Immigration Appeals, which is that last piece under the Department of Justice, BIA. The Board of Immigration Appeals decides appeals of EOIR decisions. So you have essentially in the immigration court system 2 tiers. Tier 1 is the immigration courts, where an individual who's being removed gets to present a defense against that removal. Say, hey, I don't remove me from the country because I'm eligible for such and such form of benefit. And if a removal order is issued, you typically have 30 days to appeal that order. And if the entity that you appeal it to is the Board of Immigration Appeals. It's a group of judges that's based in Virginia, and they review decisions of the immigration judge to make sure that those decisions actually follow the law. And if they decide that the decision was improperly issued, they can send it back down to the immigration courts. The Attorney General also has power to make legal decisions that are binding over the entire system. So there have been several cases where a decision was made by an immigration judge, it gets appealed up to the Board of Immigration Appeals. The Board of Immigration Appeals issues a decision or is waiting to issue a decision, and the Attorney General can sort of pluck a case from the Board of Immigration Appeals and write a new decision saying, this is the rule of the land now. And we've seen between the past administration and this one, who the Attorney General is and the posture of the administration can make a big difference in what kinds of decisions get written and how the law is interpreted from administration to administration in this area in particular. The last entity here on the sheet is the HHS, and they are relevant here for our purposes because they run the Office of Refugee Resettlement, ORR. This is the entity responsible for sheltering and processing the release of immigrant children to sponsors here in the United States. Now, for purposes of ORR, they are responsible for kids under the age of 18. These kids are classified in immigration lingo as unaccompanied alien children, UACs. And so in the next slide, you can go ahead and advance. We're going to take a look at who these UACs are and why it is that they come. So unaccompanied alien children, just side note, the language of the immigration law likes to classify any intending immigrant as an alien. These are not aliens, these are people. But the legal language, still the jargon uses the term alien. And so everyone's issued an alien number, an A number, a 9-digit number that they use to navigate the system with. So the legal language in the statutory language talks about aliens, but we like to talk about immigrants and individuals. And so, but UAC is classified as kids under the age of 18 who arrive into the US without a parent or legal guardian. And as you know, as you've seen from the news, as you know from your various fields of practice here, there are many, many, many of these kids coming across the border on their own. So, I mean, a basic question is, why do they come? So many times whenever I'm interacting with young people, sitting across from them, and I ask them, why is it that you decided to leave your country to come here? A lot of times they'll just have this generic term, una mejor vida, a better life. But what does that actually mean? And there's a lot of textures to why people leave. So one big thing is a separation from their family. Many of our kids who come across the border, one of their parents or both of their parents have already left before them. They left their home country just because of, a lot of times it's basic economic realities. They could not make ends meet. They could not make enough money to provide for their family. And so one or both caregivers at some point has left the country to seek employment opportunities in another place. And maybe they're being raised by another caregiver. Maybe they don't have an adequate caregiver at all, and they're bouncing around from family member to family member, and they don't feel safe. They don't have a stable provider in their home country a lot of times. And it's very common to see these kids where when you interrogate what life is like back home, they don't have enough. They don't have enough food to eat. They don't have enough income. They don't have enough to build a stable life that has a sense of a future in their home country, just given the lack of opportunity. What happens is that leaves people vulnerable to violence, threats of violence, abuse, enforced labor. So it's not uncommon for these kids to talk about how they had to leave school because their family couldn't afford school fees, and they start work at 13 or 14, working in the fields. Or some of our kids talk about how they would go to school and there'd be criminal groups or gangs waiting to try to convince them to join them, and they didn't feel safe, and they knew the police wouldn't protect them. They don't feel another option. So they make the journey on their own. And the journey is not a safe one. It's dangerous. It's vulnerable to abuse, extortion, trafficking, hunger, thirst, exhaustion, physical need, and lack. And then, of course, you have the trauma of being detained. We can move ahead to the next slide. And so then how is it that they come? How is it that they enter? The manner of entry can change a little bit the way that you're processed. So some kids present themselves formally at a port of entry at the border, and many other kids find their way across. They navigate by land, and they're apprehended by CBP after they enter the United States. Once they're apprehended by CBP, they get transferred to the custody of the Office of Refugee Resettlement, ORR, within 72 hours. There is a landmark Supreme Court case from the 90s that has resulted in what was known as the Flores settlement, which outlines the basic legal rights of kids whenever they're apprehended and transferred to custody. They must be provided with notice of their rights. They must be detained in the least restrictive setting, and facilities must be licensed. And so this sets certain parameters. Kids can't be detained in adult detention facilities indefinitely. There's certain speed of processing that's required, particularly for kids. Then they find a sponsor within the U.S., and that sponsor is vetted at a basic level. They must be capable of providing for the kids' physical and mental well-being. And once they find a sponsor, the child is released from custody and transferred to the care of that sponsor to navigate the proceedings on their own. And just a statistic for us, in the fiscal year 2022, 1,302 children were released specifically to Connecticut. So this is a sense of the volume of what's happening here. So after release, you can go ahead and go to the next slide. Many of these kids are placed into removal proceedings. That is, remember, ICE. They initiate these proceedings to remove someone from the United States, and it can be a long process. It all begins with a notice to appear, which is this sort of charging document, usually a couple pages in length, where they write down the right of the United States to remove this person from the country. Usually it's a list of numbers. Number one, you're not a citizen of this country. Number two, you're a citizen of this other country. Number three, you don't have any right to be here, basically. You entered this day, this time, without a visa. Legally, that notice is supposed to have the date and time of the first hearing. That often doesn't have that accurately. And they're supposed to give it to the child. Any child over the age of 14 has to receive that document themselves. Once they file that NTA with the Immigration Court, EOIR, that initiates removal proceedings, where they have a right to present themselves before a judge and explain why they shouldn't be removed if, in fact, they're eligible for some benefit. These proceedings, as I mentioned before, can take a very long time. It's not just a one and done, one hearing. Usually it starts with something called a master calendar hearing, or 2 or 3 or 4. MCH, master calendar hearing, they're these initial hearings that are held en masse. So there's tons of individuals at a single master calendar hearing where the judge will call them up one after the other and say, okay, what's the status of this? You enter pleadings, the response to the NTA. All right, you get another hearing to present proof of some other form of relief, an application for some benefit. And then eventually, once you've done your pleadings and you have some sort of relief in process, then they'll hold what's called an individual hearing, a merits hearing, which is a final hearing that's typically structured as some sort of a trial, right? Where the individual asking for relief has the burden of showing that they're eligible for relief, but you have ICE on the other side sort of questioning and presenting a case for why that relief should not be granted if in fact they oppose the relief being granted. Now, legal representation is not a given right. It's a right, they have a right to find representation and they have a right to have representation, but at no cost to the government. So at the end of the day, they're on their own for finding a lawyer. And this is true no matter how old the child is right now. And so you have no right to an attorney that is paid for. You do have a right to an attorney if you can find one, which brings up this huge access to justice issue, because these proceedings are very, very confusing. There is interpretation, but there's a lot of legal jargon. We had a client the other day who had missed a hearing, and the consequences of missing a hearing is that you get ordered removed. It's a removal order in your absence, in absentia, and that is controlling. So a judge, if they, apprehend you, you can be detained and removed without any right to see a judge if you missed the hearing because, you chose not to go. But it can be very confusing. We had a client the other day who missed a hearing and he had a removal order, but they were there in the building that day. They had just gone to the wrong floor, and they thought that by doing a check-in with ICE, because ICE will monitor your presence throughout these proceedings, they thought that that check-in was their hearing. They got another day and they thought they had to come back that day, and they were just one floor below the immigration court, but they didn't go to court that day. And so they were ordered removed. And all of this was because nobody spoke Spanish, and they spoke Spanish, and they thought fifth floor, and they just thought that they had done it. So it can be really, really confusing. And this is for adults, imagine being a 14-year-old. And so that's sort of the overview of how these removal proceedings work. You can go on to the next slide. So in the context of removal proceedings, you do have an opportunity to present yourself before an immigration judge and to explain what relief from removal you might be eligible for. You can explain that, no, I should not be removed, even though, yes, I entered unlawfully, yes, I don't have a visa, but I can stay because I'm eligible for these benefits. And most of these benefits are in the humanitarian world of immigration, because these humanitarian benefits often come with this is sort of they forgive the unlawful entry in ways that other forms of immigration relief do not. So we're just going to walk you through briefly, like the main forms of immigration relief that our young people that we're seeing come across the border can often be eligible for. And we'll start with asylum. Asylum is one that you can hear talked a lot about in the news. There can be a lot of conversation in the public sphere about how these loopholes in the asylum system, or people abusing the asylum system. But just to give you an overview of what asylum actually is, it's actually a very restrictive and very difficult to get benefit. We can go ahead and go to the next slide. What asylum is reserved for is for people who are afraid. People who are afraid of persecution in their home country. In order to be eligible for asylum, you have to meet the legal definition of refugee. Now, you've heard talk about refugees a lot of times. And when we think of refugee, we think of someone who is already permitted to come to the United States ahead of time, right? They're already qualified as refugees, and then they come. An asylum seeker is somebody who finds their way to the United States and is then asking to be categorized as a refugee after the fact, right? But the legal definition is the same. A refugee is someone who can demonstrate a well-founded fear of future persecution on account of a protected ground. So it's not enough to just be afraid or to have experienced severe persecution. You have to be able to demonstrate a nexus, a connection point between your persecution and a protected ground. You have to show that you're afraid, and you have to show that you're afraid for one of the right reasons, the reasons that are set aside by law as recognized for protection. And these include race, religion, nationality, political opinion, or membership in a particular social group. And even then, it's not enough. You have to show that the government of the home country is unable or unwilling to protect you from harm. And you have to show that you wouldn't be able to safely live in a different part of the country. And so an application for asylum isn't just something you can apply for in court. Where you apply depends on whether or not you're in removal proceedings. If you're not in removal proceedings, you can apply before USCIS. The asylum office will give you an interview. And if you are unsuccessful in the interview, then they'll refer you to immigration court. If you are in removal proceedings, you can only apply for asylum before the judge if you're an adult. But if you're an unaccompanied child, you have the right to apply for asylum before USCIS, even if you're in removal proceedings. And so Where you apply depends on how old you are and whether or not you're in removal proceedings. One brief point I want to make about removal proceedings, as I mentioned in the last point, removal proceedings aren't officially initiated until ICE files an NTA with EOIR. What happens a lot of times is they'll issue an NTA. So the child has the NTA and it believes that they are in removal proceedings. But there's been a lot of situations where ICE is delaying filing the NTA with EOIR. They're overwhelmed, they forget, things get lost in the shuffle. So a lot of times children will believe that they're in removal proceedings or they'll be on track for removal proceedings, but there's no removal proceedings initiated yet. So it's a bit of a legal limbo for those children because they're unsure if at any moment they're going to be placed into removal proceedings or if they're not going to be placed into removal proceedings. And this delay we've seen can last quite a while. So those notice questions are relevant because where you apply depends again on whether or not you're in removal proceedings, if you're over the age of 18 and are not an unaccompanied child. And generally the law requires that you apply for asylum within your first year of entering the United States. If you apply late for asylum and you don't have a compelling reason for why you applied late, you can be deemed ineligible for asylum just for having applied late. It begins with a particular form called an I-589, and then later you have an opportunity to present your evidence, your corroborating evidence of what you experienced or what you're afraid of experiencing. Now, when it comes to a particular social group, there's a lot of case law from the immigration courts, from the BIA, and from the circuit courts of appeal that can review BIA decisions about what counts as a particular social group and what doesn't. One big area of recent litigation in the past few years and lots of turmoil is for women who are survivors of domestic violence. Right now, the current state of the law does recognize a particular social group of women who are in domestic relationships but are unable to leave. So people who suffer intimate family partner violence or domestic violence. And there's various cases that have developed that to recognize domestic violence in different contexts. But it's not an automatic. You have to develop the record and explain how it is that you're a member of that particular social group and connect the violence you're afraid of to your membership in that particular social group. Something that comes up a lot is people who are genuinely terrified of violence in their home country, but because they can't prove that the violence is for the right reasons, they're denied asylum. One example that comes to mind is we had a client who was at a job, and the gang, members of a very violent gang in his home country in Central America came and said, "We need to use your workplace to store weapons." And he refused, and they beat him violently and then came back and actually murdered multiple people at his place of work in retaliation for him not doing what they said. Now, the fear was undisputed. He was clearly afraid of persecution from these same people. But unfortunately, he was denied asylum because there was no recognized nexus to a protected ground. They wanted retaliation because it's a private criminal group and they had animus towards him. They were angry with him for not obeying them. Now, we tried to frame it as a political opinion, resisting the authority of these gangs. There's a lot of resistance, for granting asylum in these situations. Meanwhile, I had another client they had not ever suffered any direct persecution in the past, but they were from Nicaragua, where there's a lot of political repression, and they had some scary interactions with the police, where the police seemed to suspect them of having participated in the protest movement, though they did not participate in the protest movement. They got asylum because their fear was very clearly connected to a political opinion or a perceived political opinion against the government. The benefits of asylum is you'll have indefinite protection from removal to your home country, and you can apply for lawful permanent resident status, or what's commonly known as a green card, after 1 year as an asylee. You can also be eligible for public benefits, just as any refugee who comes from abroad in refugee status. For the other forms of relief, I'm going to kick it to my colleague, Tess Reagan, who's going to talk about some of the other available forms of relief for survivors of violence.
Thanks, Tina. Okay. So I'm going to talk about a couple forms of relief, and we're going to talk about them mostly in the context of children and youth, just to give you some examples of how these might relate to children. So a really common form of relief is something called a U visa. A U visa is a non-immigrant visa for victims of certain crimes who have reported, participated in, or cooperated in an investigation. So the intent here is to build a relationship between law enforcement and the immigrant community. And basically, it's recognizing that if you are a victim, you should feel comfortable coming forward and speaking to law enforcement and cooperating with law enforcement. And to apply for this type of visa, there are a couple of requirements. You have to be a victim of crime, and only certain crimes qualify. In our next slide, we'll look at what some of those crimes are. You have to report this crime to a law enforcement agency and cooperate in their investigation. To prove that, you have to get a certification from a law enforcement agency confirming that the victim has been, is being, or is likely to be helpful in an investigation or prosecution of a crime. And finally, you have to show that you have suffered substantial physical harm or severe emotional abuse as a result of the crime. So before talking about benefits, I'm just going to move forward to our next slide to show you the crimes. Here is a list of the qualifying crimes. Probably the most common ones we see are domestic violence, felonious assault, the various forms of sexual contact, abusive sexual contact, rape, assault, sexual assault. Also, unlawful criminal restraint is fairly common as well. So how this works out is essentially a client is a victim of a crime. They report it to a law enforcement agency, which can, sounds like police or prosecutors, but it can also include the Department of Children and Families here in Connecticut, the Department of Labor, ICE. There are various agencies that qualify as certifying law enforcement agencies. The agency then will sign off that the client has reported the crime and has been cooperative. And then we use that certification together with a whole other packet of evidence to show the victimization and the harm that the individual has suffered to apply for this U visa. For example, some cases that we have dealt with, we have a client who was assaulted on his way home. He was, beaten in the face, and the perpetrator had an object in his hand that caused serious damage to our young client's face. He called the police, and the perpetrator was apprehended and criminally charged. And this crime was certified as a felonious assault. The client was deeply traumatized by this incident, was scared to go outside of his home. It happened right near his house. He was in therapy for a number of months. And so we included evidence of all of that in applying for his U visa. So if we just go back to the previous slide, we'll say, okay, what happens when you get a U visa? So if your U visa is approved, it's given for 4 years. And during those 4 years, you're in lawful immigration status, and you're authorized to work. After 3 years, you're eligible to apply for your lawful permanent resident status, a green card. Another benefit of the U visa is that you can include certain family members. For example, if the victim who's applying is under age 21, they're allowed to include their parents, spouses, or siblings who are under age 18 and unmarried, along with them in their application. The downside to the U visa is that only 10,000 are given out every year. And because of this limit, we have a very long line of people waiting. We have about 180,000 people waiting in line, which means that someone applying today likely won't get their U visa for, we can estimate, about 14 years or so. I say 14 years as opposed to 18 years because a certain number will get denied, but it's a very, very long wait time to receive this status. So we'll go on to the next slide, and then the next one to talk about T visas. T visas are non-immigrant visas for victims of human trafficking. On our next slide, we'll talk a little bit about human trafficking defined, but to apply for this type of visa, you have to show that you have been a victim of a severe form of labor or sex trafficking, that you're physically present in the US because of that, on account of that trafficking. You must comply with reasonable requests for assistance in investigation or prosecution, And you have to demonstrate that you would suffer extreme and unusual hardship if removed back to your home country. So if we go on to our next slide, trafficking defined. I think it's really important to define trafficking because we think of trafficking maybe from movies or how the term might be used in common language, but it actually has a very specific legal definition. And trafficking doesn't just mean that someone was, brought across the border or smuggled into the country unlawfully and then forced to do something here. It can arise after someone's arrival, whether that have been a lawful or unlawful entry into the US. And there's two types of trafficking: sex trafficking and labor trafficking. You can see our definitions here. Sex trafficking is a commercial sex act. So that means something of value has to be exchanged in the sex act that is induced by force, fraud, or coercion, or in which the person induced to perform the sex act is under 18. Labor trafficking is the recruitment, harboring, transportation, or provision or obtaining of a person for labor of services through the use of force, fraud, or coercion, and for the purpose of subjection to involuntary servitude, peonage, debt bondage, or slavery. So, an example of this might be a client I had was a child who, entered across the border by himself and was released into the care of someone. And then sometime after that was transported to an area where he began working on a farm, and he was forced to work there. He was threatened that if he did not work these very long, grueling hours under extremely dangerous conditions, he would be beaten, he would be deported. There was threats of legal harm against him, as well as physical harm against him. Now, to apply for a T visa, there is a reporting requirement. It is not the same as a U visa, where you need a certification and you have to show cooperation, but you must show that you have reported and you cooperated with reasonable requests for assistance. There are some exceptions to that. We won't get too much into them today since we're just doing a broad overview, but the exceptions are outlined here on our slide. And if we go back to the previous slide, the benefits of the T visa are similar to the U visa. It's you're awarded lawful status for 4 years. You receive a work authorization during these 4 years, and you're eligible to apply for a green card after 3 years, or a special rule for the T visa is you can sometimes apply early for your green card. Similar to the U visa, you can include various family members in your application. So sometimes it's not just status for you, but for your family members as well. And there are certain public benefits that you qualify for as a T visa, which we're going to talk about benefits a little bit later in the presentation. Similar to the U visa, there is a cap for the number of T visas that are given out every year. Only 5,000 are awarded each year. That's a statutory cap. The backlog is not as significant as the U visa, but there is a slight backlog. It's taking about 1.5 years or so to 2 years to get T visas. And we'll go ahead now to talk about VAWA self-petitions. So a VAWA self-petition is a form of application that someone can apply for if they are the abused spouse or child of a U.S. citizen or a lawful permanent resident, or the abused parent of an adult U.S. citizen. So for example, let's say I am an undocumented child, but my parent has their green card or is a U.S. citizen, or my step-parent has a green card or is a U.S. citizen, and I am being abused by that person. This status, this form of relief would allow me to apply for status without the assistance of my abusive relative. It is most commonly done with spouses, but children and parents are also eligible. The requirements are a good faith marriage to a U.S. citizen or lawful permanent resident, or if you're applying as a child or a parent, you must demonstrate the qualifying relationship. So again, in this context of a child, they would be demonstrating that the person is their parent, either biologically with a birth certificate or a step parent through marriage to their biological parent. You have to show that you have been battered or subjected to extreme cruelty during the relationship, that you have physically resided together in the same residence, and that you're a person of good moral character. The benefit of a VAWA self-petition is that you don't need the cooperation of the abusive relative, and you don't need to report to the police. There's no reporting requirement or cooperation requirement. It's simply enough that you have been abused in the course of the relationship. I'm seeing some question in the chat. Can good faith marriage be explained? Yes. So good faith marriage essentially means that the marriage did not take place solely for the purposes of immigration, so that there was an intent to build a life together with the spouse. So often we're proving that by showing, photographs together or a lease together, that you had a bank account together. Obviously, in abusive relationships, some of that is difficult to prove, but other forms of proof can be statements from friends or family who observed the relationship, who spent time with you, something like that. I'm also seeing some questions about what about adopted children? Yes, adopted children would also be sufficient. So it can be adopted children, biological children, or stepchildren. All of those have specific definitions under the law, immigration law. So you would have to meet those requirements to be able to show that you were a stepchild or an adopted child. I'm also seeing a question about good moral character. Generally, good moral character is shown through a background check to confirm that you don't have haven't been arrested for certain crimes or have certain criminal convictions. There is a legal definition to it, but generally it's proved by a background check, like an FBI check or a state check. I'm seeing some questions about UNT visas that I'm just going to finish this VAWA slide, and then we have like a minute or two for questions. So I'll just wrap up VAWA by explaining that with your VAWA, if it's approved, you get deferred action, which is protection from deportation, and a work permit. You may also be eligible to apply for green card with your VAWA. The timing depends on your country of origin and whether the relationship is to a U.S. citizen or a lawful permanent resident, as well as whether you have any sort of immigration violations that may prohibit you from getting a green card. So that was our VAWA U visa and T visa. Very quick overview. I'm just going to take these two questions about U and T visas. So one question is, what legal status does a person have while waiting for a U or T visa? Generally, they have no legal status while they're waiting. There have been some attempts to change this in over the years in terms of U visas, because Congress has recognized how long the wait has grown, and that was not the original intent. Over the years, they have created a system for providing something called deferred action for certain people who are waiting. Deferred action is not legal status, but it is an agreement with the government that they will not remove you, deport you. And you can also get work permit while you have deferred action. The process is a little complex. In the past, they assessed each case completely and put people on a wait list saying, we don't have a visa available, but if we did, we would grant your case. And it was a full assessment of the case, which ended up taking a really long time. So, people were waiting, 6 years for a U visa, but 5 years for a wait list, and it didn't change much. Under the Biden administration, they have tried to accelerate that process by changing it to a bona fide determination, where they're checking the applications for certain very specific requirements. And if you've submitted those things, you can get this deferred action and a work permit. But those are also taking a significant amount of time. For a T visa, right now, there's no status while you wait. There is certain ways to receive certain benefits with a letter you can get, but there's nothing like the deferred action program for the U visa, and that's likely because the wait times are just not as long. And the other question, nope, I think that was it as to UNT visas. Stacy, do we have time? Should I answer this one more question, which is saying, what about abuse to a child, domestic violence by a caregiver, where the undocumented parent with substantiated abuse of a minor is entitled to legal representation to claim parental rights of another minor child while pending litigation? I'm not really sure what this question is asking. I'm not sure if I'm reading it correctly.
Why don't we move ahead with special immigrant juvenile status, and we can think about that question and see if we have any suggestions.
Yeah, that may be answered in the course of the SIJ as well. But if it's not, we can circle back and talk about what it might mean in terms of a U visa.
Okay. Hi, everybody. I'm Sabrina Tavi. I'm an attorney with the Center for Children's Advocacy and director of CCA's Special Immigrant Juvenile Status Pro Bono Project. As Stacy mentioned earlier, CCA's SIJS Pro Bono Project seeks to expand legal representation for youth who are seeking this one specific form of immigration relief, special immigrant juvenile status. The project trains attorneys and oversees their representation in the first half of the process of obtaining SIJS in probate court, in state Connecticut probate courts. So our pro bono attorneys and volunteers make a critical difference in the lives and futures of immigrant children who've suffered abuse, neglect, often violence, and often extreme poverty in their home countries, and have come to the United States seeking safety. So if you are interested in learning more about our pro bono project for attorneys to represent youth in this first half of the proceeding that we're going to talk about, please email me and I'd be happy to speak with you and share more information with you. Okay, so jumping into special immigrant juvenile status, SIJS is a pathway to legal permanent residence, as well as eventually to U.S. citizenship for children who have been abused, neglected, abandoned, or in Connecticut denied adequate care, guidance, and control by either one or both parents. Now, this is a particular form of immigration relief where federal law is recognizing that children in this status need protection, and is protecting children who have been granted a certain protection by state law courts, this immigration protection, and allowing them to regularize their immigration status. Unlike some of the other ones we've talked about, this is a two-part process, and it combines that state court dependency proceeding along with the federal immigration petitions before USCIS. And SIJS cannot be obtained solely for the purpose of avoiding removal from the United States. You know, as I just mentioned, it is an integral component of it that the child has sought and needs protection in light of their status as being abused, neglected, or abandoned by the state courts. Okay, we can move on to the next slide. Sorry, I was looking at the question in the chat. Okay, so as I've mentioned, so here are the requirements that are set forth, and we're going to get down a little bit lower into the federal statute that sets forth these requirements, but these are the 5 requirements of SIJ. One is that the child or youth must be under the age of 21, cannot be married, and must file along with the petition before USCIS state court predicate decree that sets forth certain determinations made by the state court, finding that the child or youth is dependent on the state court by virtue of the fact that they've been abused, abandoned, or neglected, or denied care. That reunification with one or both parents is not viable due to that abuse, abandonment, or neglect. And finally, that the child, that it's not in the child's best interest to return to their home country. And with that factor, it's taking into account not just the parental abuse, abandonment, and neglect, but also other factors that affect why it's not in that child's best interest to return home. And we'll talk about that a little bit more below, but those factors also encompass some of those external factors that Tess was discussing, particularly, for example, in the context of asylum. So that can be external country conditions factors, violence in the area where the child was living in their home country, danger posed by gang recruitment. So it can also account for external factors such as that, in addition to the fact that if the child were to return home, for example, to a parent who abused them, or to no parent at all who abandoned them, that would not be in their best interest. Okay, so move on to the next slide. So the benefits of SIJS, as I mentioned, it's a pathway to legal permanent residency. So it allows a recipient to remain in the United States and adjust status to become a green card holder, and eventually to be able to apply to become a US citizen. But of note is the fact that they cannot later sponsor their parents for immigration benefits. So unlike, the VAWA or the T visa, for example, in which a recipient can sponsor certain family members, SIJS cannot, the recipient of SIJS can't later sponsor a parent. And that includes the parent who is even caring for the child. So, it's not only limited to the parent who abused, neglected, or abandoned the child, but it can include the guardian parent who is actively and appropriately caring for the child. So in addition to being able to obtain a green card, as Tess was just discussing, once for other forms of immigration relief, once the status is approved, the young person can then apply and may receive deferred action as well as work authorization. And we'll talk about this a little bit below, but for youth from certain countries, they may be able to adjust their status and obtain a green card simultaneously when they receive the special immigrant juvenile status. And from other countries where there is a backlog and there's a wait list for visas, they could have a significant wait. But in the meantime, they may receive deferred action work authorization after that special immigrant juvenile status is granted. In addition, once that I-360 is pending as well as granted, they are eligible to apply for Husky, which is Connecticut's form of Medicaid. But a quick note, which my colleague Angelique Torres will get into further in more detail later in the presentation, that in Connecticut, there is a statute which makes eligible for Husky youth up to the age of 12, regardless of their immigration status. So that's just a Connecticut specific statute that's not dependent on one's immigration status. And we'll get into more detail about that later. Okay, next slide. Stacey, should I pause and take some of these questions, or should I just do it all at the end?
I think you could keep going. I know that Tina is answering some as we go along, and we'll pose any to you that don't get answered.
Okay.
And at the end of the SIJ, we can pause briefly.
Okay.
Thanks.
Okay. So as I mentioned, SIJS is a unique two-part process. That first phase of the process starts at the state level in state juvenile court, and that can take place in any state court that under federal statute is determined to be a quote unquote juvenile court. And in Connecticut, that is family court, juvenile court, and probate court. And that those courts, whether how they're referred to, may vary from state to state. So in this first phase, what the child is doing is seeking an order that is declaring the child dependent on the state court. And as part of this process, the state court is making a determination about the needs of the child. And so, for example, we'll get into this in more detail below, but in the probate court, typically what we're doing is seeking a guardianship determination from the probate court based on a finding that the child has been abused, neglected, or abandoned, and that the most appropriate person to care for the child is the proposed guardian before the court. In addition, the state court guardianship proceeding provides the court with the jurisdiction necessary to simultaneously issue the decree that makes those findings that the youth is eligible to apply for special immigrant juvenile status before USCIS. So state courts are the reason why it's structured this way is that, you know, Congress believe that state courts are uniquely positioned to make these determinations regarding the status of children, that they have the knowledge and experience in making determinations about the well-being of children and their status as being abused, neglected, or abandoned. And they're used to making these determinations because neglect and abuse, child protection is a matter of state law. And so the next step in the SIJS process is, once you've obtained that predicate state court order, is to move on to applying for the actual status before the federal government, before USCIS. So the state court is not actually granting the child the immigration status, rather it is simply making the factual determinations that form the basis for an SIJS grant by USCIS. And when you have obtained that predicate order, you're going to be filing that order along with a petition before USCIS, referred to as the Form I-360. And then, as I mentioned earlier, you'll be then, if that's granted, and sometimes simultaneously for certain applicants, you would be applying for the adjustment of status, applying for the green card, which is the I-485, and then as well as you would be eligible for the I-765 if you're granted deferred action after the status is granted, even if you're awaiting a visa availability. And we can move to the next slide. Okay, so this is the federal statute that sets forth the requirements for SIJS, the Trafficking Victims Protection and Reauthorization Act of 2008, and its amendments. And this is where the requirements that we discussed earlier for SIJS are established. So the requirements being under 21, not married, etc. And it's also where the definition that is set forth of what constitutes a juvenile court, which is any court in the United States that has jurisdiction under state law to make determinations about the custody and care of juveniles. And as I mentioned earlier, in Connecticut, that's juvenile court or superior court acting as juvenile court, family court, and probate court. And so we're going to focus a little bit today on probate court, which is where we practice primarily, particularly in the pro bono project that I mentioned. Okay, we can move to the next slide. Okay. Did we move on? Oh, I'm sorry. Oh, okay. Well, at any rate, in probate court, the probate court, has jurisdiction to determine that a child is dependent on the court if the court has found that there's a basis for removing one or both parents as guardian of the minor child. Secondly, that the court has appointed a guardian or a co-guardian for the minor child, has terminated the parental rights of one or both parents, or has approved an adoption for the minor child. So probate courts are courts of limited jurisdiction. They're not Article 3 courts. And so they can make lawful orders to carry into effect the power and jurisdiction that's conferred by Connecticut law. And so what I just described with respect to removal, guardianship, termination of parental rights, approval of adoption, etc., those are some of the statutory bases. Also, a unique aspect of Connecticut probate law is the ability to appoint a voluntary guardian in probate court for youth who are between the ages of 18 and under 21. So as I mentioned earlier, under the federal statute, a youth may apply for special immigrant juvenile status up until their 21st birthday. So you may note that if you think about, when does a minor become an adult, right? When does a minor no longer under the legal control of their parents, right? And that's typically at 18 in most states. So as you can see, there's potentially, a conflict between federal and state law in terms of how a young person is defined as a minor. And that was the case in Connecticut and is the case for a long time, and is the case in many states where, there is this sort of sliver of young people who are unable to avail themselves of this immigration protection that was available under federal law to them until 21. So in Connecticut, the legislature remedied that situation by creating a probate court specific provision in which youth between the ages of 18 and 21 can petition the court for the appointment of a voluntary guardian who would be their guardian until the age of 21. And these are the factors that the court must determine. The youth has to establish that they're dependent on that competent caregiver, and that they consent to that appointment, given that they're over 18, and as well as they are at the same time filing a petition for SIJS findings pursuant to the statutory section with the probate court. So Connecticut is, one of a handful of states across the country who have made, certain provisions available so that youth between 18 and 21 can avail themselves of the federal statutory right to apply for SIJS until they turn 21. Okay, we can move on to the next one, 21. So, again, as the focus of these proceedings of this particular immigration relief is to address and protect youth who have been abused, neglected, or abandoned by one or both parents. And that's the purpose of the state court proceeding as well, right? The federal government is looking to the state court proceeding and its exercise of that traditional area of state law. So why probate court? Because the focus of the probate court is on stability planning and permanency for the child. The guiding principle in those proceedings is best interest of the child. And so we're appointing a guardian for the child so that they're guided and protected while they're in the United States. Probate court gives immediate access to caregivers to obtain guardianship so that they can make decisions on the child's behalf and plan for their future. And probate court has the authority to make SIJS findings that can allow the child to remain safely in the United States and achieve a sense of permanency and well-being. So while immigration matters may be part of the motivation for the probate court case, the primary purpose must be for the care and protection of the child. And those are the traditional goals of probate court. So we just talked about, these are some of the, the many reasons why a young person, along with their proposed guardian, would be going to probate court, seeking the court's protection, and as well as that SIJS finding determining that they're dependent on the court. They're seeking somebody who can make clear decisions for them, provide them with a safe environment, provide for future planning and stability, do practical things like enroll them in school, apply, have them on their health insurance, for example, make medical decisions. Thinking of medical decisions, a case that comes to mind is an older teenager who we represented, who was in the United States visiting a relative, and during the course of that visit, disclosed that she had been abused or was being abused in her home country by one of her parents, and she became suicidal and was admitted on an emergency basis to a hospital, and then kept for further treatment. And that aunt who she was staying with needed not just temporary guardianship to make those decisions about her medical well-being on a short-term basis, but it became clear that she needed, that it was unsafe for her to return to her home country where she was abused and not receiving mental health treatment for her suicidal ideation. So that's an example of a case in which, it's critical for guardians to be able to obtain that sole decision-making authority, as well as that accompanying SIJS determination, which would enable her to apply, the youth to apply for special immigrant juvenile status so that she could safely remain here. And thinking also about, safe environment, thinking about many cases we have in which, youth are fleeing from their home country from a very abusive environment. I have one case right now in which several siblings are here, having fled with their mother from their home country, from a father who was extremely violent and abusive. And there, in that case, when they tried to report to the government, he was very well connected, very powerful in the local community, and the local police would not protect them, and they were forced to continue to return home until one day they could flee here to the United States. And so that's also an example of when we're thinking about, making that argument to the court, not just about the basis for the abuse or the neglect, denial of care, but also for the best interests, that it's not safe for those children to return to that home country where that abuse was ongoing and where they couldn't find any relief, from local government and police to protect them as well. Okay, let's go to the next slide. So as I've mentioned, in addition to the state court, making this determination about the guardianship and making the determination necessary to protect the child or young person, the state court order, the decree, the predicate order, is serving as support for the SIJS petition that eventually that young person is going to file before USCIS. And so when you're preparing the case for probate court, it's really important, to be thinking in your drafting about setting forth an adequate factual basis that can support the abandonment, abuse, neglect, or denial of adequate care, guidance, and control in Connecticut. That's the state-specific provision in Connecticut, as well as the best interests. And so it's really important when we're drafting, our affidavits and setting forth our grounds before the probate court that we're citing a very detailed factual basis for each finding, as well as it's very important that we're also citing to the state law, because when USCIS goes to adjudicate that I-360 petition, they're going to be looking to make sure that the state court is making this determination under state law. And so when we have that predicate decree granted by the probate court or other juvenile court in the state, we want to make sure that that decree is adequately citing to the state law basis for the court's findings, and as well as the factual basis. And just a note that, to make clear that when that state court is making those determinations, obviously they're looking to state law to do that, in this case, when you're in probate court, to the probate court statutory provisions, 45A 610, which set forth the definitions of abandonment, denial of care, guidance, and control, abuse, and neglect, as well as in addition, we look to the 46B 120, which sets forth the definition of neglect and uncared for, which governs child protection proceedings in Superior Court. And the standard of proof before the probate court is clear and convincing evidence. Okay, we can move to the next slide. I think I've mentioned this, that when we're filing the I-360 before USCIS, that's being accompanied by the underlying state court decree that you've obtained, which determines that the youth meets those eligibility criteria. And as I've stated earlier, that probate court is not granting the actual status, right? They're just making the findings that the youth is eligible. And once the I-360 is filed before USCIS, that is essentially the youth asking for the consent of the Secretary of Homeland Security to grant that classification as a special immigrant juvenile. And so as we talked a little bit about, we want to make sure that the evidence, the decree that's being submitted is adequately factual and sets forth the basis of state law, so that it's granted, and that we avoid any situation with USCIS issuing a request for more evidence or a notice of intent to denial or a denial. And that can, we see that happen sometimes where that state court decree lacks an adequate, doesn't set forth adequately the state law basis for jurisdiction or its findings, or that it's not specific in its factual findings. So for example, a decree from state court that might use only legally conclusory language, for example, might state, the child was abandoned by virtue of the fact that the parent didn't maintain an adequate degree of interest or care for the child. That type of very broad, legally conclusory language, could result in USCIS issuing a request for more evidence and eventually a denial. And so we really like to see those decrees highly detailed with the factual basis for how did the absentee parent abandon the child, from what age, failed to ever provide financial assistance, failed to provide emotional support, was never a part of the child's life. This is the last time the parent saw the child. So we really want to get into those details. Or in the case that I was mentioning earlier, with those siblings who fled with their mother, very detailed information, such as father, in that case, it was an extreme case, father held gun to the child's head and threatened to kill the child. Father beat the mother in front of the child, which establishes towards the child and establishes neglect, the domestic violence against the mother in front of the children, as well as causing the child to reside in a situation or condition that's injurious to the child's well-being, for example. Anything, let's see there, also RFE. Okay, and then we can move on to the last slide here on FIJF, which is final outcomes. So once that I-360 is filed before USCIS, USCIS has jurisdiction to decide whether the child is granted the status. By statute, they must decide within 180 days, but I think normally it's taking longer than that. And then, as I mentioned earlier, if the visa is immediately available, they can also they can apply for the visa once the I-360 is approved, and sometimes that's done simultaneously depending on what country the child is from, their country of origin. And similar to other forms of immigration relief, you know, SIJS can be applied for affirmatively. So for a youth who's not in removal proceedings, they can apply directly to USCIS and have the entire determination done by USCIS if they are in removal proceedings. The judge there has the discretion over the adjustment of status. Oftentimes, once this juvenile status is granted, you know, we're going to go before the immigration judge and ask for either the proceeding to be terminated or paused while that youth is, you know, seeking the adjustment for, or seeking the green card. And here's just a little explanation about something referred to as visa retrogression, which is basically, they describe it as that essentially setting forth the priority date. So particularly for youth from these countries, El Salvador, Guatemala, and Honduras, for example, this is the most updated from February, or maybe not the most updated, but a month old, showing that, you know, they're not eligible to apply for that green card unless their priority date is earlier than March 15th, 2018. So you can see really how many years out we are here with respect to that. Okay, I feel like there's a ton of questions in the chat and I'm not sure where to start. So shall I scroll up? What?
Sabrina, we've been answering them as we go along. So I think we're ready to move on to Tess.
Great.
Thank you.
Yep.
Hi, everyone, back again. Just to talk briefly about eligibility for and access to public benefits in Connecticut. I am going to move through this section quite quickly, just in the interests of time. So if we'll go to the next slide. You know, we wanted to include this because in general, we get a lot of questions from providers about whether people are eligible for benefits or not. There's been a lot of fear in the community about accessing benefits just because of some of the language coming out of certain administrations about public charge and other things like that. So the kind of takeaway here is that eligibility for public benefits depends on lawful status. In general, an undocumented individual is not eligible for benefits for themselves. For their U.S. citizen children, yes, because that is, even though the parent is receiving the benefit on behalf of the child, the benefit is for the U.S. citizen child. But in general, an undocumented individual is not eligible for benefits. There are some exceptions to this, emergency Medicaid, and there are some exciting developments around Husky, which is our version of Medicaid here in Connecticut for children that Angelique is going to talk about a little bit. But in general, when determining whether someone can get benefits, the term used is qualified aliens, meaning they must have a specific legal status and they have to have been here for 5 years in that lawful status. That's the rule in Connecticut, this 5-year residency rule. So we'll just go to the next slide that lists out some examples of who a qualified alien is. I'm not going to read this whole list to you, but essentially the determination would be, does the person have qualified alien status? Have they had it for 5 years? Then there can be an assessment of eligibility for benefits. Just a note here at the bottom, DACA, SIJS recipients, and U visa holders are not qualified aliens, though there is an exception for SIJ recipients or those with pending petitions for Husky, which is Medicaid, if the child is under 21. So we're just going to go ahead to the next slide. So here in working with undocumented or clients who might have some varying type of immigration status, if you're wanting to do an assessment on whether they might qualify for anything, you first want to check if they're qualified aliens, and if they have the 5 years. If they're not, you would be evaluating for some exceptions. There are exceptions to certain benefits for pregnant women and children, refugees and asylees, Cuban and Haitian entrants, qualified aliens who are veterans, and active duty servicemen. So what that means is either they don't need to meet the 5 years, or they don't need to meet the qualified alien language because they fall into a very certain specific and very limited exception. We've included a link here to the NIWAP public benefits chart. NIWAP publishes this for every state. It lists out various types of benefits like cash assistance, TFA, TAMP, SNAP, Medicaid, SNAP, which is food stamps, Medicaid, SSI, qualifications for FAFSA, as well as varying legal statuses, and tells you what the requirements are to receive that benefit in each state. I highly recommend using this as a resource. It's really, really good. And I have found for the most part, very accurate. Next slide. Just a quick list here of programs that are open to undocumented persons: WIC, obviously public schools, school readiness, and an important note about public housing and energy assistance. Those are available to mixed households where you have some of the household, maybe a parent being undocumented and a child being documented, or spouses where one is documented and one is undocumented. And essentially how it works is they prorate the subsidy. So the undocumented person is required to pay, whereas the documented person would be eligible for that benefit. And next slide. So I'm going to turn it over to Angelique, and if there are questions in the chat, we'll look through those. Just wanted to get through that in the interest of time.
Thank you, Tess. Hi, all. I'm Angelique Torres. I'm the staff attorney for the Immigrant Children's Justice Project at CCA's Bridgeport office. So I know Sabrina and Tess touched briefly on the Husky coverage for children here in Connecticut. So I just want to expand on that coverage, talk about the historical context of how it came about, and the eligibility requirements moving forward now. So in 2021, House Bill 6687 was passed, and this basically provides access to Husky Medicaid for undocumented children up to the age of 8 years old, and pre- and postnatal care for undocumented immigrant pregnant women. And in 2022, the Appropriations Committee, which is basically the committee in the legislative building that oversees and votes on funding and state budgets. So they expanded this coverage up to the age of 12. So although the law or statute was passed in 2021 and 2022, it wasn't implemented until this January 1st of 2023 is when children could apply for this benefit. If you could just go to the next slide. So touching upon who's eligible. So children up to the age of 12 and who are undocumented. So basically, if you get the coverage prior to age 12, it'll cover you until you're 18 years old. However, you do have to apply and be accepted before the age of 12 as well. So when you're 13, you're not eligible, unfortunately. And it's until 12. So it's not 11 years old and the day before your 12th birthday, it's at 12. So until you're 13, it could be the day before you turn 13, as long as you just apply before 12. Before 13, I'm sorry. So how much does it cost? That would depend on your income. So Husky A is completely free. There's no premiums or co-payments. Depending on your income. Husky B Band 1, you'll have no premiums and a small co-payment. And then Husky B, you will have premiums and co-payments. Next slide. So a lot of questions are frequently asked questions that are also on the DSS website. Will this affect the ability to apply for citizenship or lawful permanent resident? No, there is no public charge. It will not affect these applications. And so what do you need to sign up? name and date of birth of everybody in the household, proof of Connecticut address, and household income. So household income could be really tricky, especially if the parents don't have, an official pay stub or a W-2, stuff like that. So DSS will accept a notarized letter from the employer or a self letter notarized as well, just because they understand that they may not have access to official documents. And so how to apply? So DSS encourages a phone. The paper application and the application online still asks for your social security number, and the way the system is set up, it'll immediately deny you, just because it's the way the computer is just set up. So they do encourage you to call in, and they would have translators in various languages readily available to apply on the phone. And then they would give you a brief period of window to send over those documents that they need. And that includes the household income, proof of residence, but they encourage applying on the phone. And so I do have a note at the bottom, and this is from my conversations with DSS in the middle of February. So hopefully these numbers are, there are more children covered, but since February, I believe it was 17th when I got these numbers, 2,883 immigrant children receive Husky because of this statute, which is amazing. And I'm hoping when I get new numbers, it'll be higher, hopefully. So next slide. So I know Tess talked a little bit at her last slide regarding public schools. So this is a benefit for immigrant children. And I'm just going to do a very brief overview of the rights that children and their families have, educational rights here in Connecticut. If you would like a more comprehensive, a webinar about the rights and the schools, please reach out to me or Stacy Violante Cote, and we'll be happy to include that. So today I would just talk about the educational rights, the right to a free public education, enrollment barriers that parents and students have when enrolling for public schools, a little bit about ELL rights, which are English language learner rights, and my resources at the end. So next slide. Okay, so I just included a very famous case. Just for historical context, this case came out of Texas. Basically, what was happening was that Texas was withholding funding for school districts because they were educating undocumented children. So that it was challenged, it was raised in the Supreme Court, and they struck the law down, basically ruling that undocumented children are protected by the 14th Amendment, which is the Equal Protection Clause. A lot of words just to say undocumented children do have a right to free public education here in the United States, and that their immigration status is not relevant in establishing residency when enrolling your children in the school district. So yes, undocumented children up to the age of 21 who have not received a high school diploma can go to a public school. Next slide. So once you're already, trying to get enrolled, the parent and the child go to school. So some enrollment barriers that have are to my knowledge and have been occurring are requiring parents to supply a child's birth certificate or social security number. Typically, sometimes parents don't have these documentation, especially social security number, but it could be the child's birth certificate, depending if they have this. So technically, yes, a school may request these documents, but they cannot deny enrollment to the student for the lack of providing these documents. So they can request it, but the Department of Justice has stated that the districts must accept a variety of documents that can verify the child's age or just identification purposes. So it doesn't have to be these specific documents, as they may be hard for undocumented communities to have. So they may request it, but again, they can't be denied for not having it. Disclosure. Okay, so that's basically the slide. Next slide. So once the child is enrolled, they typically, if they don't speak English, they will be labeled as an English language learner. So I just want to go through the process of how they're identified and what that looks like for them. So once you enroll, the school will give you a home language survey, and this survey identifies the child as an ELL student, which is English language learner. I would just use ELL, is shorter for me to say. So honestly, that survey isn't much like a multiple choice question. It's not a survey in what I think a survey is. It's just a questionnaire that asks basically your name, the identification of the student, and what language is the native language at home, and the student's native language. So that will be submitted to the school, and they will designate and identify that student as an ELL student. And so the testing right after, typically a language acquisition skills survey, which is a test that measures a child's, it measures for speaking, listening, reading, and writing, their skills in those areas. And in that, there's an entry LAS and an exit LAS. And this is just to monitor the progress of the student. Basically seeing where they were when they entered and where they are at when they are leaving the school or the end of the school year. This can monitor their progress and could identify even more issues. Maybe it's not a language issue and it could further into something else, but it's just a way of monitoring the student's progress. And in terms of communications with the parent, whether the scores or any communications, the schools should be talking to or sending letters to the parent in their native language. That is covered federally, as well as I'll talk a little bit more in my next slide about providing ESL or bilingual education to the student once they're identified. That will depend on how many students of that language are in that school, but that would be the typical education that they would receive. And again, the school will continue to evaluate the child's progress into the next school year as well. Next slide. Okay, so one could ask whether a child is going to receive ESL or bilingual education, how is that determined and why? It is determined based on how many students are in that school speaking the similar language. So in one school, 20 or more ELLs who speak the same language will receive a bilingual education the following year. And if it's fewer than 20 students, the school will provide ESL. And typically the difference is that ESL will be taught by a certified teacher trained to teach English. So it is taught in English, whereas bilingual education will teach you both in English and the native language of the students that are 20 or more, since it's a bigger population at that point. If it's less, the budget or the way it's taught is in English by a certified teacher. So these services are given up to 60 months, while also, remember that the school is also monitoring the success and the progress of the student. If after up to 60 months, the child is still not progressing the way the mastery standard scores are in Connecticut, they will continue to receive services, whether that's language transition support services. Next slide. So just touching on the language transition support services, that could include summer school, after school assistance, tutoring, just a more services in order to, after the 60 months of actually having the bilingual education or ESL, to continue providing limited services while the child may not necessarily be in the bilingual education at that time because it is after 60 months. So again, the child's progress is assessed annually. Again, this is from the language acquisition skill survey that monitors, speaking, listening, writing, and English, I believe. Yes, listening and reading and writing. So again, that's on a scale of up to 5, I believe, and 4 and 5 is a mastery level. Whereas, below that, they're still receiving services as well. So under federal law, districts are required to monitor the academic progress of the students, even though they have reached English mastery standards. So they may not necessarily be in their ELL programs, but their grades and their academic record is still monitored up to 2 years after, just to make sure they're acclimating to the normal course load and just making sure that they're receiving the services and they don't fall through the cracks, just in case there is a regression or something else is actually happening during the process. And that is a very brief overview of ELL. Again, if you would like a more comprehensive, because it could get very detailed, just reach out to me and Stacy, and we will be happy to have a full webinar on just ELL, because it is progressing and there's some bills on the legislative floor at the moment regarding this type of issues. Thank you.
All right. That was a lot of information. We do have some resources here for you that Angelique has provided on English language learner resources. And then if you go one more slide, I think I referenced in the chat some of the low-cost legal resources. Someone had asked about possible referrals. And I do want to underscore that we will be sending out these slides to everybody who registered for today's webinar. And I'm just putting Angelique and my email in the chat because if you had questions, as she mentioned, about English language learner services or something that we weren't able to answer as we've been going along in the chat today, you can reach out to me. Reach out to Angelique for the ELL questions. So I think, oh, and I see in the chat there, thank you, Iris, to include Iris as a low cost or free legal resource. I will add that to the slide before we send that out. That was my error in not including Iris. So we will do that. So we want to thank you all. I know this was a lot of information. If you want to throw, I think we would have time for 1 or 2 more questions in the chat. We will keep our eye on that for a moment. As we're waiting to see if there's any more questions, I really want to thank our very knowledgeable presenters. I want to thank them for not only preparing and presenting the information, but also being active in the chat and trying to answer all the questions as we go along. I think that this was a lot of great information, and we hope that it arms you all with ways to think about when to refer children and youth to legal resources, what benefits they might be entitled to, and also thinking about them in school and thinking about some of those places where you can be asking for language acquisition skills testing, or you can be advocating for that they get the home language survey and ensuring they're in school. As one of our participants in the chat mentioned, sometimes you do have to ensure that the school district knows they're entitled to attend school. So please do continue to think of the Center for Children's Advocacy as a resource for the challenges you face in working with this population. And we will place this webinar on our website and send it out to participants. So be on the lookout for a follow-up email in your inbox. And I think with that, we're going to close out today. Thank you, everybody.